Your client told him they couldn't sell it. So now you're telling me they can refuse to let him sell it and then say he can't sell it now because the lot has too much back rent on it? Yeah, so she was being evicted by the owner of the trailer. That's not on point with this case. That's not on point with this case, and it's disingenuous for you to imply to the court that it is.
I disagree, Your Honor.
How do you disagree? It's a different owner of the trailer. Owners have different rights than the park owner of a lot.
Your Honor.
The person that owned the trailer Brown was living in had Brown evicted, and as part of that eviction, she lost personal property. That's the same as an eviction on an apartment or a single-family residence. There's a complete body of statutory law dealing with evictions of mobile homes that's not there.
So the termination of tenancy case, Your Honor, they would have had 90 days to sell the home. This was not a termination.
But my point is you're presenting Brown as if it's analogous to our situation here, and it's not. It's a completely different fact situation. Well, guess what? I'm wearing the black robe and I say it's not. So Brown is not in my decision-making today. So if you've got something that's analogous to this fact situation where you were evicting a trailer off the lot that you owned, but you had no ownership interest in the trailer, then I'd love to see that case law.
The Turner case, Your Honor, once again, is a claim that there was wrongful moving and storage of personal property.
Let's start with who did the eviction and who owned the trailer. Go on.
Once again, there was a claim that there was a wrongful removal of property that was taken to a storage facility. The court held that the removal was proper.
But who owned the trailer?
It was foreclosed upon by Bank of America.
Okay, so Bank of America was the owner.
It wasn't foreclosed, I agree.
Yeah, but they owned it. At the time of the eviction, Bank of America owned title to the trailer, correct?
Yeah.
Who was evicted?
The purchaser.
By Bank of America, the owner. So once again, totally different fact situation than Clay versus Park Estates.
Finally, in Barnaby versus PCI, it also is an order of eviction. And the claim was that
Don't tell me the claim. Who was the plaintiff in the eviction?
was the landlord.
The owner of the unit.
I don't believe so, but let me.
Well, if they were the landlord, if they weren't the owner of the unit, how were they the landlord?
Because they leased the unit.
So they were acting on the auspices of the owner. I lease it from Clay. Clay rents it to Landman. That means Clay is the owner for eviction purposes.
I don't, Your Honor, I understand what the court is saying. I don't believe that it is separate and distinct because of the fact that you have an order of eviction.
My eviction authorizes the court officer to get a trailer off your lot, not to go in and dump all the property to the dump. Never in my tenure on the court have I said to the court officer, go ahead, take personal property out of a trailer that the plaintiff does not own and throw it away. That's not what my eviction orders are meant to do.
The eviction order, and in this case, in the case that I provided, and in all three of these court of appeals cases, instructs the court officer.
Counsel, you're not catching what I'm laying down here.
I know exactly.
Your client did not own the trailer that the eviction took place at. So all those case laws, the evicting party owned the trailer. You're talking apples and pork chops. We're not even all in the same fruit basket here. So I hope you do. I hope you appeal it. So let's talk about your other reason for the directed verdict. What statutory or court rule authority do you have that I can't take testimony alone on value?
Take testimony, Your Honor. It's got to be supported.
Where's that at? I'm asking you for the court rule.
Claim deliveries is 3.1. I think it's 3215. I'm not sure.
Take your time. Sure, counsel, take your time. Mr. Clay is going to go get a drink. No, he wants a break to get a drink. Go. Just don't talk while he's out of the room.
Your Honor, the court rule is 3.105. 3105C2
Hold on a minute. Okay, I didn't know he was back yet. All right, go ahead.
requires that the value be stated.
I'm sorry, counsel, 3.105, what? Right,
3.5C2 requires that a complaint state the value of the property, which is not an admission of value. So therefore, in order to establish value, the proofs have to stand. You have estimate from Mr. Clay. You don't have any supporting documentation whatsoever.
okay, anything else?
Any foundation for value to the
Once again, I can't tell you how to present your case, but you don't have to have original receipts to establish value.
So,
I said original receipts for purchase is not the only way you can establish value of an item to the court. Anything else? Okay. All right, counsel, grant your motion. Let's move on to the counterclaim.
Your Honor, as I looked at the counterclaim, the judgment was against Mark Clay. So I do not believe that George Clay would step into Mark Clay's shoes. So with that in mind, if Mark Clay decides to file a lawsuit, we will go ahead and pursue a counterclaim against Mark Clay.
I think that means you're dismissing your counterclaim. You're right. I'm sorry? Any objection to the trailer being sold?
If the trailer is titled in George Clay's name,
Who's got the title? All right. So I'm just hearing that's the only worry they,
well, $16,000 they say that rent. And that's why they have.
okay, well, he just admitted you don't owe any rent. He just said he's letting his counterclaim go because you're not the responsible party for back rent.
See that? Okay.
That's what I just heard.
I'm not letting it.
Okay. All right.
there may be future litigation. But I suppose if that occurs, then we'll have the issue of whether there are claims that should have been claimed here. Because in a meeting, you say a claim.
I don't like to talk about how many angels can dance on the head of the pin. So if it comes up, we'll deal with it then. All right. Questions?
Well, that tell Parker State that I can only rent and I can sell my friend.
The grant was for the lot.
Which has nothing to do with the trailer. Would you agree?
Doesn't have anything to do with purchase price. Home's been sitting on the lot for now several years.
Because you wouldn't let him sell it. Your client told him they couldn't sell it. So now you're telling me they can refuse to let him sell it and then say he can't sell it now because the lot has too much back rent on it? Then we're going to be back here for another claim of delivery because you've forcefully taken the trailer.
Well, I don't believe you're going to file our own claim of delivery. That has to be.
No, my point is you can't, on the one hand, you can't say, sure, go sell your trailer. And on the other hand, say, but you can't sell it now because there's too much money owed on the rent and somebody's got to pay us that. You can't stop him from selling the trailer and then hold him responsible for the lost time. So the man needs some direction. Are you authorized to tell him, put it up for sale and get it out of there?
The authorization to try the case based on claim delivery of the spot.
What about your family?
He just dismissed that.
Hold it back, right?
Yeah, but he just dismissed it.
Okay, but
And I can't stop him from dismissing his case. Right. So I think what I'm hearing from him is you got to sue Park Estates because they've taken your trailer.
Okay.
Have they deprived you of its use and value?
Yes,
That's a taking.
and they have, last year, they made me mobile homes.
You got to go see a lawyer, Mr. Clay. You got to go see a lawyer. Because a lawyer would have walked out of here with a judgment against them today for claim of delivery. And I know it's throwing good money after bad, but good luck. Have a nice day.
Or the judgment about anti-IP.
Yeah, I think, Carly, we got to e-file that judgment, don't we?
Yes, Judge.
Yeah. Thank you, Mr. Lehman. All right, Jamie, would you turn that TV off?